Daily list, item number 1, pronouncement of judgment.
I'll read only the
Lordship, yes.
In view of the above observations, this court holds that the said impugn opinion and order have been passed without any application of mind and law, and therefore the case of the petitioner for grant of remission is required to be reviewed. The operation of the impugn order dated so-and-so of the Secretary to the Government of Meghalaya, so-and-so, as well as the opinion dated are hereby set aside and quashed, without the necessity of the petitioner having to file a fresh application. The concerned authorities would take up the same from the record and consider the same following due procedure. This exercise is preferably to be taken up within 4 weeks from the date of communication of the order to the Secretary, Department of Prisons and Correctional Services, Government of Meghalaya.
Lordship, we have 45 days.
Why 45 days?
Lordship, they will have to, because if we are to go by their new remission policy, Lordship will have to take the opinion of the district judge also. Let it be 45 days, Your Lordship.
45 days.
45 days. Highly obliged, Your Lordship.
Note down them to you.
Obliged, Your Lordship.
Wait, please, Your Lordship. I beg to make a mention of item number 5. I'm praying for some time in this matter, Your Lordship.
2019 matter?
Your Lordship, 3 weeks' time may be given, Your Lordship.
No.
The school has not yet appeared. What is the case about?
Your Lordship, this is a service matter wherein my service has been treated as contractual even after serving for 20 years in the school.
And what is your status now?
Your Lordship, 2 have already retired. 1 is still in the service.
How many petitioners are there?
3, Your Lordship.
3. 2 have retired.
Yes, Your Lordship.
You have not brought that fact to the court? Or this matter has not been heard?
No, Your Lordship. 3 weeks, Your Lordship.
On prayer made by the petitioner, not objected to by respondent, matters adjourned, recessing after 3 weeks.
Highly obliged.
Item number 2,
Yes.
May I please, my lord. My lord, by this application under 4 be a necessary petitioner before your lordships, seek for direction of this honorable court for the grant of bail in view of the accused in connection with the session case number 20 T of 2024, my lord. And my lord, in this case, if I may, that notice has to go to the complainant. There are 3 complainants. I have read them as respondent number 2, 3, and 4.
Three complainants?
Yes, ma'am.
What is this case about?
The case is in the evidence stage.
No, what is the subject matter?
Subject matter is
What is the contents of the FIR?
content of the frequent rapes of the committed by the accused against the victim, who is a differently able person.
And who are the complainants?
Complainants 1 and 2, the mother and parent of the victims, and complainant number 3 is the president of the Mandari Association of the area where the victim is resided. FIR, my lord, you find at page 14.
So the victim was a or is a major.
Yes, it's a major but differently able person. She's 19 years at 21 years at the date of incident.
You study this aspect of Mr. Harmi. There is a order passed by this court. Because that is in the POCSO matter, where notice to the complainant in this POCSO matter.
Yes.
That is with regard to bail.
To bail.
This court has
Kept that matter for passing the order.
No, that has already been passed. If I'm not mistaken.
It's today. Let's check today also.
Okay.
One matter. But
As to the mode and modality
yes,
of
it's
how
today.
notice is to be effected.
Yes, Lord.
Not necessarily that the survivor or the complainant is required to be arraigned.
Arraigned as party.
But how the notice is to be
issued.
If option is given to them whether they would choose to appear,
participate or to appear.
or not. So I thought I've already passed that.
No, your lordship has kept that order. Has kept that case today for passing the order. It's item number 3.
Okay.
Item number 4 today, lordship.
That matter has not been heard because the parties are required to give their views.
In criminal appeal, your lordship has passed the order.
Criminal appeal.
That is settled.
Now, as far as cases where the victim is a major, or rather when the case is not under the POCSO Act, this is a regular IPC section. Even then, it involved 376.
376.
And 439, was it 439-2?
Yes.
Where specifically special mention is made with regard to section 376D, all those sections where the the victim is required to be made known or to participate in the proceedings as far as bail is concerned. But the fact is, this court is to consider as to whether they are required to be implemented as parties, to be informed well.
Yes.
That's another aspect. But to be implemented as parties, because implement as parties means exposing
identity.
The identity or related identity of the victim, which is, I don't think that is the scope or the intention of the lawmakers.
In the criminal appeal and revision, your lordship has decided if this desire, the notice will go through the PP or the PI or the IO, if they so desire. But in this bail matter, that is kept open.
What we will do, Mr. Suna,
My lord.
we'll take up this that issue for consideration before any order is passed. If an order is passed in the other case, then so be it.
Yes. It's item 4 today.
We'll post this matter after a week then.
Yes. After a week.
On pre-made with the parties, this matter after.
Obliged.
If any order is passed there, then it will be applicable here.
My lord.
If it comes to
Yes.
that.
Yes. Obliged.
Obliged, my lord.
Item number 3.
My lord, in item number 3, notice is yet to be effected. We tried to serve him through the police, but he couldn't be found at the address. So we will be sending by registered post. This is for cancellation of bail, my lord.
So you want to take fresh steps?
Fresh steps.
Ms. S. N. Leonard G. appearing for the petitioner, state petitioner, has submitted that notice. Has submitted that the petitioner has tried to effect notice upon the respondent, but the same proved futile as he could not be located in the given address. It is therefore prayed that some more time may be given for the said notice to be effected. After the petitioner has ascertained the correct address and location of the respondent herein. Accordingly, as prayed for, let fresh notice be issued upon the only one respondent, isn't it?
Yeah.
On the respondent.
My lord, if the counsel appearing in the main matter can also help us with the address, we'll be grateful.
But he is not here. He may not have
Not here.
instructions
My lord.
on praying it. The last line. The same returnable within 2 weeks. This is the matter thereafter. Excuse me.
Item number 4.
Your Lordship, I'm praying for notice for the respondent number 3 in this matter.
Yes, miss. Have you read the last order? What is the
That it
what is
might be
what is
sent
stated
through
therein?
IO or through register mode.
So simply saying notice to be issued, is it good enough? You are called upon to assist the court as to how the I will not say impasse, but as to how the matter is to be resolved as far as the question of notice, issuance of notice is concerned. Yes, Mr. Khan, what do you say?
Lordship has already decided this matter and POXO matter. Bills, but 439A, as Lordship said, 439 says at least informant has to be informed, except for the mode of service. So leave it to your Lordship.
That order was passed in an appeal, isn't it?
Appeal, criminal.
But not in a bail.
Not. So Lordship, so for POXO,
can you show me some precedents?
Lordship, 439(1)A says the informant has to be informed in a matter of notice, in matters of bail.
Yes, of course.
439(1)A, Lordship.
Where's the corresponding provision in the POXO Act?
POXO Act they have filed under your POXO Act. Lordship, so far, just can you have POXO Act? 31A, Lordship.
Yes, application of these CRPC.
Lordship, yes. So 31 says clearly. And under BNS's lordship is 483. They have come under 483.
I think this provision has to be amended. Section 31 has to be amended.
Lordship is.
Because now CRPC has been.
Well, lordship is correct. Absolutely correct. The nomenclature has changed. It cannot be CRPC anymore. It has to be BNS.
Okay. So what is your submission as far as the mode and manner in which notice is to be issued? See the provision says it's obligatory.
Obligatory?
Of course, obligatory sometimes means mandatory.
It could be
not necessarily statutory, but then it's there. So whether it's must, shall, will, or may.
That is a tricky area. Lordship is correct. So lordship to play safe. Maybe if they've since they've arrayed as a party, and we are not constrained by any precedents. Neither we are guided by the. Even 483 doesn't say the mode. It just says obligatory. The mode has been left to the discretion of the court. To play safe, lordship, if they've arrayed as a party, let them file a service report and then serve copy on that.
True. But we have to settle this issue once and for all.
The lordship, that is correct.
I think in the other case
lordship,
you have referred to the decision
Lordship has discussed at length all the high courts and then affirmed why this should be the mode. If that is the case, lordship can rely on that judgment and can say the same mode. Either it can say that, but since we are dealing with statutory here,
yes,
and per se legislature has not legislated saying what should be the mode. So the discretion is always with the court. So lordship, leave it to the court. Court can rely on its own precedent, or court can say the party should be arrayed to make matter more simple. Because lordship, how notice should be served, that also is a tricky area. Because if the notice is served and then they come eventually and says no, we never received the copy.
So if the direction is to be given to the IO to affect the service.
To affect the notice.
So what happened is the IO will have to file a report.
Lordship, correct.
Through the prosecution.
Lordship, correct.
Prosecutor, whatever.
Absolutely.
So the onus shifted.
Onus is shifted, yes.
It's shifted to you rather to the prosecution.
On the issue of notice.
On the issue of notice. And also to ensure that if, more often than not, we don't know what would be the state of mind of the complainant or the survivor if survivor is more often than not, the survivor is not the complainant, herself. It is always the father, mother, relatives, whatever.
Absolutely.
The informant rather. That's what
that's what the word informant, yes.
So, if the informant chooses not to participate, matter ends there.
Exactly.
But if the informant would desire to participate, then it's incumbent upon the IO to file the proper, notice with the correct opinion.
Exactly.
And if so, to inform the informant as to the date when the case is fixed, so that she can appear. So that exercise is left to the IO now.
Absolutely, lordship is correct. Not only notice has to be served, also has to be informed on date and also whether she or she wants to participate. And there's also one more rider, Your Lordship, whether if she doesn't have the mean to engage a lawyer, supposing, then the legal aid issue comes in.
Legal aid, yes.
But Lordship, just kindly for a minute, if you pause and if we look back at the whole steps that we are taking, it could be time consuming a lot. So we have to also keep in mind that the report of the IO, either they want to engage the lawyer of their own choice, if not, then legal aid. The moment legal aid, then they have to file an application before the registry. Now, who will file an application, the IO or the informant? And then the lawyer has to be engaged through legal aid. So then, effectively, when you have to do the bail hearing, from the date of motion till the hearing date, it could take a month. In a situation where they don't want to engage lawyer of their own choice. The moment they want to engage lawyer of their own choice, date is informed, then we have a scenario where on the next date, everything is heard. So that is one area, Your Lordship, like we have to tread a bit carefully so that bail may become only for the purpose of notice, it may take a long time. That is one thing that we have to bear in mind also, Lordship. Because once court set into motion this procedure, so we also have to be very careful then the issue of delay or time consuming, and without proper legal aid also then will be difficulties.
But this is the, if from what I could understand, if I
Guwahati and Bombay.
remembered all those.
Yes, Delhi, Bombay.
Delhi, Bombay, Guwahati.
Yes.
They are of this, of this same trend. That this is the preferable, mode to be adopted now. Of notice to be affected by IO, then legal aid to be afforded to them. So
my only apprehension, Lordship, is this: there is no harm in following her, but then the court will have an extra burden in terms of supposing in urgent matters we can't consider. So even if the case diary is called, so the role of IU will become a bit less secondary. Primacy is to be given as to serving of notice and their appearance, if not legal aid. So
there is also another way out. The court will look into the petition. If CD is to be perused, then the next day CD will be called for. And if the court feels that the petitioner has not been able to make out a case, matter ends there.
Absolutely correct.
There's no requirement for the, for the survivor or the informant to be made a party.
Lordship, we are grateful, Lordship. At least that clarity will guide the court also, yes.
Only if the court is of the opinion that yes, the petitioner does have a case.
Prima facie, there is a case.
Then.
Without touching the merit, but it appears from the case, right, there is a case, then says the hearing is must. That clarity can come, Lordship, I agree.
Whether we can embark into that exercise?
Absolutely correct. Lordship, whether we are guided by any statutory rule to embark, or whether it's an innovation by the court and by the prosecution. So that is also an issue. For a moment, Lordship, we can try it out. On subjective satisfaction, prima facie, if the prosecution can satisfy, then notice becomes. If there is no prima facie, then maybe court can embark. Lordship is correct.
This is bail or anticipatory bail?
Bail.
Bail. How long was the accused in custody?
Your Honor, almost 3 months.
3 months. We'll wait for another week. In the meantime, the parties can, if you feel like, you can give me, written synopsis of your contention or submission, and I'll pass necessary orders as far as you said, as far as the mode and method for effecting notice on the
correct.
Foreman.
Absolutely, Lordship.
Heard. counsel to the parties on the issue of whether the informant, public complainant, in a case under the POCSO Act is required to be made a party, if so, what would be the mode and manner in which notice is to be effected. On consideration of the submission made, this court would consider the court would take into account the inputs given by the learned counsel at the bar, and also the gist of written submission to be filed in due course. Accordingly, this is matter for orders. Today is 24th.
Jim, after 10 days, Lordship, please can it be considered? After 10 days, next week.
10 days. You have to bear in mind that the accused is in custody. You cannot just delay unnecessarily. Let's keep it on first Tuesday.
Tuesday could, Lordship, Tuesday could be a holiday. Eid. So that's why I had that in mind.
Eid.
Most holiday, 30, 31st. We don't know. So third, Lordship, please. Can you consider whether third?
Huh?
31st of February, we don't know.
Or 31st Monday, Tuesday.
So we have always have a situation every year, sighting of the moon.
Okay. We'll fix it on second or
third, Lordship, please. Third. Oblige, Lordship.
This is a matter on third. But can you do that within a day or two? Your written
Lordship, yes.
Suggestion, I would call it.
Lordship, we'll do. One will do.
Please do.
Oblige, Lordship.
Item number 6.
Come on.
Yes.
Your Lordship, and a DSGI is on legs before courtroom number 2, Your Lordship.
Sorry. Court number 2. All subsequent matters are connected.
All connected.
All subsequent, except for the last.
These are all on the same issue of cancellation.
Same case. Same, yes. Same case as well.
Same case.
Same case, except for the last one.
Except for item number 10, Your Lordship, 6 to 9 are connected matters.
But facts are, the situation is similar.
Similar and
Fairly
in same case, Your Lordship.
Fairly similar.
In same case, different accused. And in item number 8, Your Lordship, I have filed affidavit because he has died.
Deepu.
Neetu Sharma.
Oh, he has died.
Yes, Your Lordship.
He is the only, but he is one of the accused person.
He is one of the accused. But his case was separately filed, Your Lordship. Item number 8. And I have filed affidavit bringing the death certificate.
So we can dispose of this case.
Yes, Your Lordship.
Because as far as the accused is concerned, see, the criminal proceeding against him has
Your
abated.
Lordship. It will be abated only after the death, Your Lordship. After the death of the accused, the case will be abated against him.
Yes, so he has died, isn't it?
Yes, Your Lordship.
Said after the death, I mean, maybe he will die
Sounded like that.
after 7 days.
He died on 29/12/2024.
So, Miss, yeah, I don't think it's required for you to make any submission.
Lordship, if I may just seek instructions. Sir might
The
come.
person died. What instruction? The person has already died.
Yes, sir, I understand.
On prayer made by the Mr. Leonard Counsel has sought for accommodation on the ground that the Leonard DSGI is indisposed and could not appear for this court. Could not appear for this court to take up this matter. Accordingly, on prayer made, list this matter tomorrow. Take it up tomorrow.
Good evening.
Declare.